Hello, everyone. Thank you to the audience for returning to the 24th Annual George Mason Law Review Antitrust Symposium. I am this panel's moderator. I am Babette Boliek, and I am moderating the panel in my personal capacity as Professor of Law of Pepperdine University. Any views I may express do not necessarily reflect those of the United States Department of Justice. This is day 3 of this year's virtual program. And earlier today, you may have heard from Bruce Kobayashi and his panel on FTC remedies. And now I'd like to introduce this group of distinguished panelists who will be discussing the topic of antitrust and collegiate athletics. Our panelists are Michael Carrier, the Distinguished Professor of Law at Rutgers Law School, Michael Hausfeld, founder and chair of Hausfeld LLP, James Keyte, Director of Global Development at the Brattle Group, Matt List, Vice President at Charles River Associates, and Hal Singer, Managing Director of Econ 1 Research. I please invite you all to go and see our great panelists' bios for further information on them. And we're going to delve right into today's topic. So, Michael Carrier, I'd like to start with you. As we talk about the topic of antitrust and collegiate athletics, we can't but think of 2 cases of O'Bannon and Alston. And if you would, please set the stage for us of how the courts have addressed those 2 cases, what kind of analysis they've approached these 2 cases with, and what we might look for in the petitioner's arguments in NCAA v. Alston.
Great. Well, thank you so much, Babette, and thank you to the George Mason Law Review for putting on such a timely and relevant conference. And this panel in particular is about as timely and relevant as you get. We think about college sports. Sometimes we have a warm feeling. So I'm part of Rutgers, the Big Ten. I went to law school in Michigan, saw some other serious Big Ten football. And so the question is, well, what exactly is college football and basketball? What role do the student athletes play? How important is amateurism? And it really is fascinating to think about amateurism, this notion that perhaps student athletes are not paid, and to trace that through the decades. So you go back through the 1970s, 1980s, up until today, and you see that the NCAA has relied on amateurism as its #1 defense. Whatever it does, whatever restraint on trade, whatever it says about players or any restriction on players, it's all allowed because of amateurism. And what we have seen in the past few years in the O'Bannon trial and now in the Alston trial is that for the first time, amateurism has been front and center. My sense is if you go back through the decades, the NCAA really got the benefit of the doubt. Amateurism sounds like a good thing. Sounds like apple pie in America. Who wouldn't be against players not being paid? The problem, though, is that the more attention you put on amateurism, the worse it comes out. And so we saw lots of evidence in the O'Bannon trial and the Alston trial. And just to set the stage, O'Bannon was several years ago. Ed O'Bannon, former UCLA basketball player, saw his name, image, and likeness in a video game, didn't like him, so brought a lawsuit so he could get some of that money. And then in Alston, you had a lawsuit that was a little more expansive in seeking some money, education-related, non-education-related, above the cost of attending a particular school. And so we had 2 trials for the first time. And in those trials, we saw that amateurism perhaps is not the most consistent term in the world. Maybe the NCAA is changing its definition all the time. Maybe it really is no more than what the NCAA says it is. And so I think the trials have been a bit of a setback for the NCAA and its prized defense. And so in the latest case, the Alston case, we had a petition for cert at the Supreme Court, and the Supreme Court granted it. And so we are expecting oral argument at the end of March on this issue of what amateurism is all about. The petitioners, who are the NCAA and the athletic conferences, really raise two arguments. The first argument is that they really shouldn't be subject to antitrust scrutiny at all, that these sorts of restrictions are pro-competitive as a matter of law. And if you look at their brief, they say, well, it's not really an immunity, but it actually is. And so really, it would be the end of scrutiny for things like amateurism, because that is so essential to the product that the NCAA puts out and therefore should not be subject to scrutiny. The second argument that they raise is that the courts in the Alston case applied the rule of reason incorrectly. Let me spend a bit more time on that. I feel a particular affinity to the rule of reason as an academic. I don't have to be normal. And so one of those things that I do is I read all of the rule of reason cases. I enjoy that. And I've read all 897 rule of reason cases. And so I care a lot about the rule of reason, and I care a lot about when courts say it's a three-step analysis when it's actually not, it's a four-step analysis. And I'm grateful for the George Mason Law Review in 2009, who published one of my empirical studies on the rule of reason. So let me quickly just walk through the four stages of the analysis. The first stage looks for anti-competitive effects. In my surveys, I found that 90% of rule of reason cases are disposed of on the ground that there's no anti-competitive effect. Since 2009, that number has gone up to 97%. So plaintiffs almost never satisfy the first stage of the rule of reason. In this case, in contrast, in Alston, this was a slam dunk. None of the courts in O'Bannon or Alston, not even the petitioners in their briefing, have questioned the fact that there was, quote, a severe anti-competitive effect, according to the courts. And if you want to get into it just a bit more, the court said that the restraints, quote, suppressed competition and fixed the price of student athlete services, and that the student athletes were forced to accept whatever compensation was offered. So there's no doubt in this case that the plaintiffs cleared that first stage. Then the question is, well, what about the second stage? The second stage, to me, has been very frustrating in this case, because the second stage involves a defendant offering a justification for its conduct. Now, under the rule of reason, the defendant can't just pick anything out of a hat, can't say, well, I don't like competition, but I like to set up my product there whatever way I want. It has to be an antitrust relevant justification. And the frustration for me here is that the NCAA has spent a lot of time talking about amateurism without really recognizing that amateurism is not a pro-competitive justification. Amateurism is how it sets out its product, but that's different than an effect on, for example, consumer demand. And so in this case, the courts, just like in O'Bannon, took the NCAA's defenses based on amateurism and basically gave them a helping hand. Said, you know what, that's not really a defense, but we will look behind the scenes to see if there is a real effect on consumer demand. And the courts found that there was an effect for some of the restraints, not the ones that deal just with education, but maybe those that deal with the cost of attendance, those that don't deal with education. So basically, the courts helped the NCAA out in finding some antitrust relevant justifications. Then we get to the third stage. Third stage has confused courts and commentators like no other stage has. Big picture is that the third stage allows us to have our competition cake and eat it too. In other words, if the plaintiff can show that a restraint is reasonably necessary to attain the defendant's justification, or that there is a less restrictive alternative, then we can, again, have our cake and eat it too. We can survive. We can allow the defendant to satisfy their objectives and do so in a way that is less restrictive of competition. I mean, what's wrong with that? And so when it is satisfied, and in this case it was satisfied, then it's really straightforward. Now, we have to be careful that with less restrictive alternatives in particular, we don't engage in second guessing after the fact. You can always look at an alternative and say, well, it could be a little less restrictive. You could always focus so much on the alternative that you forget about the link between the alternative and the justification. And so some of the courts that have engaged in this analysis, and most of them seem to be in the 80s and 90s, according to my research, did engage in these problems, and I criticize them for that. In this case, in contrast, the court applied an extremely high bar. The court said that the alternative has to be patently and inextricably stricter than necessary. In other words, it's so strict that it really has nothing to do with the justification. And that's the analysis that the court applied. The court also applied its pro-competitive justification, again, twisting the NCAA's one because it really wasn't offering one when it focused on amateurism. So at the end of the day, the court found some less restrictive alternatives. There were 3 that were accepted. The first was limiting the grant in aid, things like tuition and fees, room and board, things that you just need for a college experience. That's one thing that the NCAA could affect. The second was limiting compensation and benefits that are not related to education. NCAA seems to be on more solid ground there. And the third was for those that weren't related to education, they couldn't limit it with the exception of academic and graduation awards and incentives, because those could be a lot higher. So at the end of the day, the court was willing to see a less restrictive alternative, which means that the plaintiffs won at that stage. If the plaintiffs had not shown that, we would have gotten to balancing. My guess is that given the severe anti-competitive effects and the very limited justifications, the plaintiffs would have won, but we did not get that far. So in short, I think that this was a rigorous application of the rule of reason. I think that the NCAA should be subject to scrutiny for potential antitrust violations, and the petitioners are challenging those 2 things. They're saying first that the NCAA basically should not be subject to scrutiny, and second that the courts below messed up on their rule of reason. And so that would be how I would set the stage for what's going on in the case.
Well, thank you, Michael, for a great primer and a great way to introduce yourself. I want all the panelists to identify which NCAA schools they attended and their rankings. So well done on that as well. But as we go around the panel and bring everybody in, I want to invite the audience to be thinking about questions that interest them and reach out to the George Mason coordinators so that we can start getting some audience questions later on as we discuss it. But sort of a fun sort of popcorn round that I'd like to get everyone's input on is we do have, as Michael said, we do have the Supreme Court has accepted cert on a case known as NCAA versus Sean Alston. Why do we think that they have done that? And I'd like to get the economists on record on that. So I'll start with Matt List and Hausinger. What do you think the court will be interested in? And you can add, what are you most interested in seeing in that particular case?
Sure. So I guess I'll start off by saying, I went to Boston College. So you read some of these cases in the NCAA, and there's always these discussions of, why do schools offer athletics? Many schools, you see this in the Knight Commission, say that they're losing money, that there's transfers into the athletic program. So I think just, we often think of college athletic programs as huge money makers in and of themselves, but I think the stories can be more complicated. And part of that, to go to my own college experience at Boston College, I think it's viewed as this tremendous spillover effect of the school from their football program when Doug Flutie beat Miami and kind of put the school on the map. But thinking about why this case and why cert was granted here, I think back to a college campus, thinking of how the NCAA is described in some undergraduate economics textbooks. You sometimes see these undergraduate texts that describe the NCAA as, is it a cartel? Is it a monopsony? And they kind of walk through the simpler case. And I think what we see in these, Bannon and in Alston is that the story is more complicated. Because in both cases, I don't think what we're seeing here is a pure monopsony story. I don't think we're seeing cases where there's an allegation that any constraint on player compensation should be removed. Instead, we're seeing, more nuanced stories. So in both, Bannon, for example, there's a less restrictive alternative put forward that is tied primarily to the cost of attendance. And then there was discussion of a small $5,000 compensation on top of that was ultimately dismissed. And then even in the Alston case, like Michael said, the NCAA seems to be on firmer footing for the non-educating related expenses. Much of the less restrictive alternatives that were put forward are still tied to education. So I think right off the bat, what we're seeing, to me, what I'm seeing is that there seems to be a general recognition that there's potentially some pro-competitive role being played in the NCAA as kind of governing player compensation, which isn't dissimilar from how you'd view the economics of a professional sports league or another association. So I think that makes it interesting from an economic matter, because it seems like there's a pro-competitive story. Everyone, maybe they had differing views on how important it is, but I think what we're seeing instead is that I think the parties are saying there's some pro-competitive aspect of governing player compensation. But then between the O'Bannon case and the Alston case, it seems like as the parties put forward these different less restrictive alternatives, we're running into this soup is too hot, this soup is too cold. It seems like we run the risk of potentially having a story where there's second guessing of which is the right less restrictive alternative. Again, because I don't think the parties are saying there should be nothing, but it's more what is the right number. And so I think, as an economist thinking about this, it seems like maybe the court, I would hope, is looking at that and trying to give us, a better judgment of where some of this lands. Because I think, again, back to Michael's point, in a lot of these sports cases, the pro-competitive aspects, I think the pro-competitive justifications get put forward in any sports case, whether it's collegiate or not. I think the criticism there sometimes is that they're not always well-defined. You hear competitive balance and as a pro-competitive justification in both the pro and college level. And I think the pushback there sometimes is that, well, how do you define that? And I think that's not so dissimilar from what we're seeing here in the course of in the context of amateurism. What is an amateur and what's not. But there does seem to be a recognition on both sides that there's a desire to make college sports or keep college sports something that's not just a pure minor league.
Thank you, Matt. How?
Yeah, well, since Matt and Michael both brought up this concept of amateurism, I just would like to take it straight on, if that's all right. And the first point I want to make, I think the whole concept is a hoax, and let me just try to defend this position. The NCAA got $7 billion from ESPN for the right to broadcast the college football playoffs from 2014 and 2016, and $11 billion from CBS and Turner Sports to broadcast March Madness from 16 to 2029. And I just ask, how could a multi-billion-dollar enterprise, where everybody is making tons of money except the athletes, be characterized as anything but professional? I think that amateurism is an artificial construct that is justified, that is used to justify the exploitation of largely Black athletes in football and basketball. I note that according to a 2015 study by two UMass Amherst professors, negative racial views about Blacks were the single most important predictor of white opposition to paying college athletes. And so I would submit that having a taste for amateurism, which is supposed to be this offset for the obvious harm to workers on the other side of the equation, is really just code for having a taste for exploitation, or even worse, a taste for white supremacy. Would we tolerate a wage fixing conspiracy aimed at 16-year-old children because consumers on the other side of the market had a taste for child abuse? Would we tolerate a wage fixing conspiracy aimed at massage therapists who are forced to live at the studio because the consumers there had a taste for bondage? I mean, where does this fixation with the consumer's welfare and the primacy of consumers in antitrust end?
We'll bring in our lawyers, James Keyte and Michael Hausfeld. You can respond or go back to our original question, was what are we thinking brought this acceptance of cert of the Supreme Court, and what are you looking for in the case, or respond to what other panelists have said. I'll start with you, James.
Sure, I'll start. And those are, interesting in a wide variety of perspectives on the question. And I think it highlights part of what I'm going to conclude, which has to do with whether or not the court really took this because it thinks this complex issue is really for a legislature as opposed to an antitrust court. I think the starting point is this notion that this is a slam dunk anti-competitive effect when you're describing the product. I think it's a difficult one if you look at what the Supreme Court has actually said in the past, in 1984 or 85, whenever the NCAA did its case on broadcast restriction, it spent several pages describing what the NCAA product is. And it described it as essentially amateur college sports. And I think the way the court is going to look at this, and I think from an antitrust perspective, you look at this is the NCAA is a collaboration that creates a product. And the Supreme Court has said that is a product. It is one of the most popular products, as Hal kind of highlights, in the economy and in history. And the court also said that the not paying student athletes is an essential aspect of the product. And we can really debate that, but to me, that is more of a legislative debate. If you don't think that that is a product that society should have that has an aspect that you don't pay student athletes in the creation of the product, then that really should be for the legislature. And I think we're probably going to end up there. If you look at it in pure antitrust terms, I think it's actually a simple case in the other direction. They said it's a product, it's a distinct product. The court, back in the first NCAA case, said it is necessary, it's essential for the NCAA members to coordinate on what the product is, what the scope of the product is. How do you keep it to be an amateur product? And then we have a later case, American Needle, that said, in a rule reason of an analysis dealing with a collaboration, if the coordination is essential, that should pretty much be able to be approved fairly quickly on essentially a defendant's version of the quick look. And so amateurism, at least in my view, and I think it's consistent with these decisions, is not a defense to a facially anti-competitive labor restraint. Amateurism is the product itself. Again, we can debate whether that should be allowed. And once it's recognized as the product itself and the coordination on its scope is essential, that becomes the purview of the NCAA to define that. And so I actually think the court is going to take this case essentially, I think, to say that collaborations can create their own products. We recognize this as a product. And if there is, and that the courts below, what they did wrong is essentially they start off by saying the product itself is anti-competitive, facially slam dunk anti-competitive, and that the rule of reason 3-step approach here was skewed in that direction from the beginning, and that it shouldn't head that way, and that should really go the other way. And then if you don't like the nature of that product for all the reasons highlighted, including what Hal said, that truly is something that should be addressed in the political legislative process. I think that's why they took it.
Well, I think Jim has given us probably two of the best reasons why the court should not have taken the case. The first, I do think generally the Supreme Court, first in the baseball cases that it used to rule on, had I guess a nostalgic flirtation, with America's pastime, and they found that great deal more interesting than some of the other cases that they had to decide on. I think there's part of the same issue of alumni, with regard to college athletics, which really is not the broad spectrum of college athletics, but it's more of big game, D1 men's basketball and football. So we're not talking about the swimmers or the tennis players or the archers. We're talking, as Hal said, the big time enterprise of college athletics. From an antitrust perspective, I think that there are those justices who are very much interested, as James said, in the rights of joint venturers to create a distinct product. But in saying that, James said not paying student athletes is essential to the existence of the product. He didn't say amateurism is essential. And that's a conflation that is constantly being made, is whether amateurism is nothing more than synonymous with not paying an athlete. And then when you ask, what does pay mean? Who's paying it? Is it the school paying it? Is it the NCAA paying it? Is it a third party, paying an athlete? Until in the 1950s or 1960s, athletes in basketball and football did receive pay. And then it was switched in terms of instead of calling it pay, it was calling a scholarship. And you receive a scholarship, and the scholarship was, up to O'Bannon, just room, board, and tuition. O'Bannon challenged that, and then it went to cost of attendance, which was higher. And then in Alston, it said, well, not even cost of attendance was enough, that you could add on, education-related expenses. So the pay keeps growing, but we keep not considering it as pay, despite the fact that in any economic term, it is compensation for athletic performance. The issue under amateurism, as the court has expressed it in Board of Regents, is that those two sports, basketball and football, but again, in Board of Regents, it was solely football. It was the alleged revered tradition of amateurism. I don't think anyone at any of the cases, or any economist has established that big game, Division I men's basketball and football has a revered tradition of no pay. And on top of which, college sports had popularity and was created, while the Big Ten, for example, had a limit of the conference universities only having no more than 3 paid members on the team. So the game of college sports was created without a no pay restraint, gained its popularity over time, and then even when the NCAA came in and put a no pay constraint on all athletes, there were numerous scandals that were ultimately revealed that there was pay made, to athletes. The athletes were never expelled from school. They may have been suspended from a game or two, and the games were not, disbanded, and the game gained in popularity. No economist at any time has established in any litigation that either amateurism or no pay was essential to having big time college sports at all.
Let me do a little bit, just a quick response, and then we can go to the others. It's very interesting. Again, we were schools. I went to Harvard. I played a couple of sports there and had the chance to go play professional baseball out of high school if I wanted to. And I could have. It's not the two sports that you're talking about. But what you're really talking about is, this is really just these big sports, and it's like professional sports, and they should be paid like professional sports, even though this is what the NCAA creates as a product. The problem really probably from that perspective, and is not so much with the NCAA, is the foreclosing the opportunities for those players to go play in professional leagues. And so I don't know why we're not talking about here restraints or definitions of in football and basketball in the professional leagues that prevent student athletes, young student athletes from just going right to those leagues and getting those opportunities. Now we know when we have that, as you've probably many of us have dealt with, then you have the non-statutory labor exemption and you have collective bargaining. And so if you look at from that foreclosure of that opportunity, that's a different issue. That's an issue with the professional sports leagues. And again, I just, if it's so simple, as Michael and Michael say, I think, I don't think the court would take this case if it's just a slam dunk labor restraint. I think they're going to let the NCAA have the product that they created and that has been recognized. And I do think some of the issues raised by Hal certainly are very, very important issues, but are not really antitrust issues. I think they're important cultural and legislative issues.
So I'm wondering if I could respond to James and the discussion of Board of Regents. And so I thank James for bringing up Board of Regents and American Needle, because it really is a proxy for what the petitioners are doing in this case. I don't know if I'm aware of any other time that petitioners have relied so much on a case that they lost. Petitioners cited Board of Regents 145 times on 61 separate pages in their briefing. Board of Regents was a case in which not only did the NCAA lose on their agreement that television restraints were supposed to help the NCAA, but also the Supreme Court said, not only does this violate antitrust law, but we're going to apply a quick look type of antitrust analysis. So if I ask any of my students today, oh, do you know NCAA? None would say, oh yeah, that's the case that helped the NCAA out. And so I think that there is so much attention on Board of Regents that there's a lot going on. So the first problem there is that this was dicta. Again, the Supreme Court held in that case that the television restraints violate antitrust law. They had 2 pages in which they said, well, there are other things that might explain why this is not per se illegal, but we don't want to focus too much on amateurism. And when James is talking about what is essential to the product, this was also what the petitioners mentioned in their brief, but they put an ellipsis so they didn't have to say what the court was talking about. In Board of Regents, the court does mention amateurism as not being paid. But if you look at, and this is page 101 of the Supreme Court's opinion of 468 US, what is essential? They say 3 things. One is the size of the field. You need to have rules on the size of the field. The second is the number of players on the team. Has to be agreement on that. And third is whether physical violence should be encouraged or prescribed. Those were the 3 things that were the essential rules that the NCAA had to have an agreement on. Amateurism was not in that list of 3. And again, go back to the NCAA's brief, the petition brief here, that is nowhere to be found. Other problems with relying so much on Board of Regents is the context. You look back at 1984, what was the Supreme Court doing? Supreme Court was taking all these per se rules of illegality and saying that's not appropriate. Economic analysis is appropriate. Factual analysis is appropriate. Do we really think that in a case in which amateurism wasn't even an issue, that the Supreme Court would have barred discussion of amateurism? And the NCAA in that case wasn't even talking about amateurism. And so you have, if you look at the O'Bannon decision in the district court, there is testimony, this is page 999, where their counsel admitted during oral argument that, quote, it might be able to get more viewers if it had semi-professional clubs rather than amateur clubs. In other words, the NCAA was not relying on amateurism at the time of Board of Regents. And then finally, if you look at the author of Board of Regents was Justice Stevens. Stevens was famously known for a whole bunch of opinions in the 70s and 80s, things like trial lawyers, engineers, Board of Regents, where he said things like a private firm doesn't get to choose whatever antitrust values it wants to promote. You can't pick these social values and protect them from ruinous competition. So if you look at the holding of the case, NCAA lost. If you look at the context, getting rid of per se rules, and if you look at the author, then there is very, very little support in Board of Regents. And let me just briefly mention American Needle. So in American Needle, we do have that twinkling of an eye, which could be read to support the upholding of a restraint. Board of Regents cannot, because Board of Regents, twinkling was used to condemn a restraint. Nonetheless, American Needle was about rejecting the NFL's argument for immunity. So then there's some dicta on the type of analysis to be applied. And if you look at that, and this is on page 203 of the Supreme Court's opinion, the court talks about, quote, a flexible rule of reason. You look at footnote 10, what does it cite? Doesn't cite a case for deciding something quickly. It cites Chicago Board of Trade. Let's look at everything in the world, and it cites engineers. And so you can't look at all of that and say that all of these restraints are upheld in the twinkling of an eye. There's a lot in there for a more robust analysis.
I have a 10-second response, and then you guys, I think, because I think it's worth that. I think there's an important distinction to be made between what the product is and what restraints are in the distribution of that product. So it's simply that the NCAA case, Board of Regents, described the product itself as not paying the student athletes. And then dealt with a restraint, which was different than that, which was allocating markets for broadcast. And so I think, yeah, they lost that issue, and the court found it fundamental that the product itself involved not paying players. And so again, yeah, you could talk about restraints that are related to a product that already exists, but the question here is, and I think it's a fair question for perhaps a different body. Should you be allowed to have a product that, in some people's view, has an inherent restraint in it? But this is the product created by this legitimate collaboration. And if you can't have that product, that's really not for an antitrust court to say, oh, we in society don't accept that as a product. Because that's all this case really is about, is whether you're going to accept the idea of, call it amateurism, Michael, or not paying players, whether you're going to accept that as a collaborative product. And that's really not for an antitrust court.
And if I could have just I'm sorry, Michael, go ahead.
All right, and then you can add to it, Michael. The difficulty, James, is in the Board of Regents case, the product was not college sports; it was a broadcast license. Which entity between the school, and the association had the right to control those? That was the product, not college sports.
Oh no, there's no doubt, Michael. We're dealing with the dicta. We're not dealing with what the case was about. We're dealing with the 2 pages of dicta describing that, in contrast to the amateur product they create, where you can't pay players, we're not going to let you then coordinate without this look on how you broadcast. And so, sure, it's dicta. I agree with that.
But okay, but you just slurred into exactly what the greatest difficulty is, and that is just assuming that the product would not exist, as Michael said, without paying the athletes. Oh, by the way, and the language in Board of Regents says must attend class and not be paid. So there was the concept that the athlete was a student, a registered student. So is it you need both and not paid for what? Other students attend college, receive scholarships with no restriction on whether or not they can get paid for work outside or even inside, that they may perform with regard, to the school. But in college sports, the men's basketball and football D1, you can't be an athlete and have a paper route. It's not that you can't be paid to play the game, it's you can't be paid from any sorts for anything. And what happens under the NCAA rules if you're a high school student and you participate in a tournament and you can win a monetary prize? Under NCAA rules, that's not permitted. So where does the not be paid translate into what you said, that the product would not exist at all, when in fact the product was created with those athletes being paid? So it's the constant, what can I say, subordinating the fact that there has never been any establishment that the product was not created without a no pay restraint, and has existed throughout its history with there being serious incursions of pay into college sports, and the product has continued to exist. So where does essential come in, and where does pay come from? In particular, when you're dealing with either having a paper route or being able to get a part of a license that someone wants to acquire for the personal use of your name, image, and likeness.
Yeah, look, there's no doubt that
No,
one could create a different collaboration. But that's the question: is it for an antitrust judge to say, well, I don't like this collaboration, I think it should be tweaked here and there, or is it for a different body if you're going to do it that way? A collaboration gets to create the product that they want, and I think that's what's reflected in this being treated in 1984, 85 as a distinct product created by the NCAA, a very popular one.
I do want to bring in my economist on this, because you just said a lot of economists peak words. It sounds like we're talking a lot about product definition and versus restraints, maybe to create different product aspects. And Michael Hausfeld and James, you also, as well as Michael Carrier, when you're talking about this, you brought in a lot of conversation, for example, that there might be different cognizable antitrust markets. I think Michael Hausfeld, you mentioned that as Hal has said, that there's this FBS and these very lucrative broadcast deals for some sports, but as you mentioned, not swimmers, not other sports. How are we supposed to think about coordination or the definition of amateurism in those instances? Is it amateurism per se, or certain markets slightly different because of the way that we're defining it or defining the restraints? James, you also brought out, this comes to a question, arguably, of the coordination as to the scope of amateurism. Matt, you mentioned before sort of changing definitions of amateurism, for example. And interestingly, James, you brought in where does the NFL come into this, or NBA? And arguably that comes into when are they going to step up as competitors? Right now, they limit entry, arguably, so they're not competitors with NCAA. Is that a relationship that bears antitrust examination? So all of this sort of coordination, what does this, is NCAA the right joint venture to coordinate on this? Is there differentiation even within the NCAA market? I'm gonna fling that to my economists, Matt List and Hal Singer, to discuss.
So I think maybe the way to start with that is just thinking of analysis I don't think has been kind of fully vetted yet of what the but-for world looks like in petitioner's world. So in a world where, say, what does a world look like where there is no NCAA oversight, say, of compensation? If we go back to the 1940s world of we're going to pay players, I think the analysis can't just stop at what happens to consumer surplus, maybe the product changes, but also how that comes back into the athletes themselves. Arguably, there might be some benefit to them. So I'm thinking, when you think of college football, college basketball, you have 100 some odd schools playing, and not all of those athletes are the superstars who are going to get an NBA draft offer. And I think I was looking at one study the other day, and it's a bit dated now, but they looked at Division I basketball, and I think they found that something like most athletes, if you try to recover their marginal revenue product, they're basically covering 60%, 60% of their scholarship. So basically, there's some athletes who maybe in a counterfactual world, they'd be paid well beyond what they're being compensated in the form of their grant and aid and their other scholarship monies. But then, once you get outside of maybe the starting five of the basketball team and a couple bench players, you now end up with some players who maybe in a world where you kind of just move purely to compensation, that maybe those players are worse off. So I think to really think of this, we need to think of what happens, not what necessarily did the world look like pre-television, even pre-NCAA Board of Regents, which kind of changes the game in and of itself. Largely what we're dealing with now is money that's coming from broader TV carriage and cable TV packages. But what would happen if you took the product today and started compensating athletes? What happens outside of the Big Five? Potentially what happens outside of the Big Five football conferences ends up being very different than what happens in the lower levels of Division I, or what happens outside of the couple of dozen athletes who may get a top draft pick each year versus what happens to the walk-ons or the less maybe the less well-recruited athletes. I think that's a way to think of the consumer surplus does potentially translate back into some of these athletes themselves and how they may be a beneficiary of the current system.
Let me pick up a bit on what Matt just said about the but-for world, which is presumably why you have economists on the show. But so let's play it out, right? Which is athletes today under this wage fixing conspiracy are keeping something. Estimates have been made something on the order of 20% wage shares or pay shares, and there would be a gigantic shift of the pie in the direction of the schools towards the athletes. The pay shares would move up. And how would that happen? Well, market forces would determine how much each athlete got. But I think it's pretty safe to presume that across all athletes, the pay share would be significantly higher than 20%. So that's the clear windfall, the gain that would come from ending this illegal wage fixing conspiracy. But I will grant you on the other side of the market, on the viewer side, demand is going to stay strong for sure. The product is not going to go away. But there could be some consumers whose willingness to pay, and these are these consumers with the so-called taste for amateurism or white supremacy or exploitation, their utility could fall. I will grant you that possibility. And then we have this question of balancing, right? What should the court do when we have a known harm to workers on one side of the market, right? And this purported benefit from this perverse taste, I would submit, among a subset of viewers who have a taste or a desire for exploitation. What should a court do in that instance? And I would submit that in these types of monopsony cases, that these offsets that are efficiencies that are not that do not redound to the worker, but instead to a third party, in this case to the viewers, should play no role in the decision making. I don't think that courts are equipped to make those balancing decisions. We certainly don't in merger cases. In Philadelphia National Bank, the courts were instructed not to engage in such multi-market balancing. And it's not a knock on judges or courts. I mean, as an economist, I wouldn't know how to advise a court on how to engage in these sorts of balancings. What if we have hypothetically a $20 billion gain for workers and a $10 billion loss from these consumers who have a taste for exploitation? What do we do? What do we do with that balancing? I wouldn't know what to tell a court to do with that. And so I would just submit that what we should be doing is we should get out of the world of these cross-market balancing. And if a plaintiff in an monopsony case can demonstrate that a restraint has harmed it, right? And there are no compelling efficiencies that redound to the benefit of that worker class, that's the end of the story.
Yeah, I just don't know. I think it's more complicated though. Just going back to the player compensation side, the aggregate pool maybe increases potentially, but I don't know if you can say that every player is better off. Because I think you're seeing now too. You look at colleges. This is mentioned in some of the materials from the case. They're competing. They're limited in their ability to compete on maybe dollar compensation. They're competing in other ways. So they're building training facilities. They're investing in coaches, and investing in coaches could be seen as a negative for some. But if you're an athlete with aspirations of making it to the NFL, maybe you perceive a big benefit of getting the chance to play with Nick Saban or being exposed to others or having big weight rooms and fancy equipment. I just think it's a complicated system to unwind, and I suspect you'd probably have some players maybe better off, and you might have some players who are in the system today who could be worse off. I think the skill distribution across, say, a football team is so varying that it's hard to unwind that and say for any individual how they're affected.
But the elements that you're focusing on are at the fringes. How much more a player would be better, for example, if they got some compensation as opposed to none, and how much fall off there would be if certain elements of the viewing audience that gave up on the game. But the Supreme Court established a high bar with regard to creating a distinct product. They said it had to be essential for the existence of the product at all. So in a but-for world, has anyone established that college sports, in particular D1 men's basketball and football, would disappear totally if the no pay rule was removed? You may get you may get differences in terms of individual player compensation. You may get differences in the viewership of the audience, but that is not eliminating the existence of the product at all.
I'll respond to that a little bit. I think what the court was talking about in the NCAA when it's the need to coordinate on those standards was kind of a preview of more of a competitive balance to make the product more attractive as opposed to existing at all. I think another thing, at least to highlight is a fact, I don't know the figures I've heard in the past that it's 1, 2, or 3% of student athletes who go on to play professionally. And so there's some 95% plus athletes that are getting educations or the opportunity for an education that they can make use of, that has value. And I think that is a factor. The other thing is, I think a very interesting question about the but-for world, and how I would take issue with how this marketplace is going to would play out. Because if you think of it, it's 1 to 2, 3% that have a really particular great value in a couple of sports. That will then draw all the competition, all this money from broadcast that everybody's talking about. And what does that then do to those sports, to those schools, and then to other sports and all NCAA schools? I think you end up essentially with probably losing a lot of sports. You certainly have some, as Matt was kind of highlighting in this spectrum of talent, you're going to have, a handful of stars being compensated an enormous amount and everybody else essentially not. And I understand what Hal is saying. Well, there's a lot of money to go around, and so it's going to be spread out. But I don't think it's going to be spread out. It would, in the but-for world, it's not going to be spread out in a way that preserves, and I think in any form, the breadth of sports across all NCAA sports and all divisions. That is part of the system now.
Yeah, so I think the conferences will be differently situated. And so some will be a little more professional than others. But I think the big question here is, rather than all of us speculating on what would happen, if amateurism really were so crucial to the product that the NCAA puts out, why would they never even look at consumer demand? And so there was one study that came up in Alston where their experts said, well, would this affect your views if you knew that the student athlete was amateur and or not paid? And so tons of problems with a survey question like that. But at the end of the day, the NCAA has documentary evidence and witnesses that they didn't consider consumer demand. The expert in Alston barely considered consumer demand. So why not actually think about rules and their effects on consumers? I also think if we're talking about products, and this is something that the petitioners spend a lot of time talking about, I don't see how the NCAA is in a privileged position above any other entity or association in the American economy today. So in antitrust law, there are three types of analysis: per se illegality, quick look, basically illegality, and the rule of reason. Cal Dental said, well, that maybe there's something in between. But there isn't a type of analysis of per se legality. In other words, you don't get to define your product and then say, aha, we are immune from antitrust law. But it seems like that is what the petitioners want. And it's particularly concerning because there are a lot of other entities in society that have just as strong, if not stronger, pro-competitive justifications than what the NCAA is offering. So why should the NCAA basically have immunity from antitrust law when professional sports, for the most case, do not, when standard setting organizations do not? Go back to the BMI case, when music package licenses do not. All of these are considered under the rule of reason. As my research has shown, plaintiffs almost never win these cases. 97%, 99%, they never win these. And so rule of reason is a really deferential form of analysis, but it's not clear why, if professional sports, standard setting organizations, and so many other pro-competitive ventures in society don't get per se legality, the NCAA should.
Sorry, James, go ahead.
Yeah, just real quickly on 3 points on that. One, the notion that the NCAA has a problem with consumer demand is more than questionable. It's the most popular. It's product that it creates in a collaborative way. It's one of the most popular products of all time. The idea that in a rule of reason, you have to defend each feature of your product and to see whether it generates consumer demand is a whole new analytical framework that I certainly had never heard about when I was following this case, and seems to be highly misplaced. And then finally, this immunity question. There is no doubt that American Needle, and I think after American Needle, I don't have the circuit, the cases at the tip of my tongue, but there are a couple of NCAA cases that read American Needle as a defendant's quick look, and it's a matter of characterization. As Michael Carrier, you even highlight, the NCAA case in 1985, you had to decide, they're kind of highlighting, and we're not talking about amateurism here, we're not talking about the basic product, we're talking about a separate restraint, and we're going to analyze that differently. And so I think there is a characterization analysis that certainly is required to say, well, are we into the basic product itself? Are we into restraints related to the product? And courts have to go through that, and they have done that after American Needle.
Yeah, and in terms of consumer demand, it's clear that the NCAA was not focused on the effect of its restraints on consumer demand. It's documentary evidence in the case. The expert barely looked at consumer demand. Again, it focused on amateurism, but that's a different question than consumer demand. In terms of what amateurism is, you look at what the court said in O'Bannon. It basically is malleable. It revised numerous times in significant and contradictory ways. You look at Alston, it's circular, it's not coherent, it's whatever the NCAA says it is. Sure, we can talk about the sky falling and all that, but that's exactly what the NCAA has been saying for decades. And as the other Michael said earlier on, in the past several years, there has been a lot more money flowing in the players' direction. How many people are not watching college football because now the players are able to get some education-related benefits, for example, relating to tutoring or a musical instrument? People are not going to watch college football because of that. The NCAA is always moving the goalposts, and there's no showing that's affected consumer demand at all.
Can I just make 2 quick points in response to James? This 3% figure, or whatever it is, let's call it a small percentage, James, go on and are eventually able to monetize their skills in a professional setting. I don't think that statistic is helpful for you, right? Because that suggests that the vast majority, 90+%, are exploited in the production of billions of dollar enterprise and never have an opportunity to monetize. That just goes to the issue of that these athletes deserve to be paid because they're productive inputs into a production that's generating billions of dollars, and they're being exploited by the fact that they're not getting paid. The second thing that I want to respond to is this notion that this isn't within the ambit of antitrust. I think you said that about 3 times. That if we're upset, or if it upsets our value system, that in the year 2021, we have a plantation mentality of not paying these predominantly Black workers, right? I would submit that a wage fixing conspiracy is directly within the target of an ambit of antitrust. If antitrust can't take on a wage fixing conspiracy here, then can it not take on a no poach case that spans across different firms, in a high tech case or within a franchise? It seems to me that you don't like the outcome that the traditional antitrust would take us, as laid out by Michael Carrier. And so you're suggesting that you want an out or an exception or maybe a per se legality. If you want to go to the legislator and tell them that you want an antitrust exemption because you don't like the outcome of a traditional antitrust application here, then by all means, you guys can go ask for it, right? But I think this fits squarely as a wage fixing conspiracy. It fits squarely into the ambit of antitrust.
No, and I understand you do, and I'm going to set aside some of the other characterizations and not address them that you're making. But with respect to the characterization that this is just essentially a per se wage price fixing conspiracy, you're ignoring what the Supreme Court has already said with this is a collaborative product. And you have to then deal with the law of collaborations, which takes you down a completely different road. And that's why what I'm saying is that if in fact, and I understand exactly what you're saying, Alec, but if in fact there is a prevailing view that this collaboration is actually nothing more than a monopsony wage fixing conspiracy, when the court has said no already, it's a collaboration and it's a distinct product, then that is a legislative question. That's all I'm highlighting.
The difficulty, James, with that is, again, what is the collaboration? It's the collaboration in the concepts, as Michael Carrier said, of a sport. And courts have recognized that sports need collaboration in the size of the field and the rules of the game and the spacing of the yardage. That's fine. No one's contesting that. But you keep
citing the Supreme Court.
being no, you keep.
I'm not making this up.
I would say it's a misciting, because you're a revered lightning rod, and in doing that, you keep coming back to the product, all right? And you say the NCAA created the product. The NCAA did not create college sports, nor is the NCAA maintaining college sports on the basis of its amateurism, which is Michael Carrier, pointed out, and as both courts in Alston and in O'Bannon did, that is an ever-shifting, a definition. It is what the NCAA says it is, and it is clear that the universities compete to recruit the players. And were it not for the fact that they are paying the players in the form of scholarships, which differ, by reason of the school, that the athlete is recruited by, those wages will be different. And the contract between the university and the athlete says, in exchange for your performance as an athlete, we will pay, your room, board, tuition, or now cost of attendance and these other items. That is a traditional, wage relationship. But for the fact that the NCAA did not want to be accountable for workmen's compensation and general legal accountability for injuries by the athletes, they said, you are not employees. So we're not really paying you a wage. We're giving you, a wage payment, but in the form of a scholarship. So again, those are nuances or niceties that never come out, but that is the reality of what this market is.
Michael, you've done a very nice launch into some audience questions. So one question is dealing with this relationship of the NCAA with the schools. It echoes what we were talking about, how there's disparity among the sports, but there's also disparity among the schools. And so the question from the audience is, how's the court supposed to deal with the huge disparity between schools, alone athletes within the NCAA? While some of the NCAA's pro-competitive arguments from Board of Regents and O'Bannon might work for some schools at the lower rungs of D1 football and basketball, for example, integrating student athletes into the overall campus, competitive balance, output, and education, they don't seem to hold up for most of the Big Five, the football conferences, and the big March Madness contenders. So how are we supposed to think about the disparity within this large joint venture, which is the NCAA?
Well, the disparity is a reflection of the market realities. James mentioned before, and one of the defenses that the NCAA raised in O'Bannon was they needed the no pay rule to establish competitive balance. And but there are numerous studies out there that there is no competitive balance. It's the same schools for the most part that you see in all the the final tournaments and winning the final titles, because there's a Big Five that has an advantage over the rest of the 450 schools that comprise the NCAA in all three divisions. There's going to be imbalances within the system, but that doesn't mean the game disappears. I believe there's a footnote even in Board of Regents where the court notes the fact that if you eliminated some of the imbalanced games, or what they call body bag games, where the superior schools maybe playing teams that have less resources, that there would be more popularity for the games of like schools, of competitive that were competitors, as opposed to a competitive school taking on a non-competitive school. So it's the market that's going to determine really where the sport should go under traditional market principles.
Right. And so I agree with that. And I think that the market is the key. And the conferences will have different levels. So the Big Five will be very different than the smallest schools, but that's the market working. And I think the judge below in the Alston case was a bit worried and said, well, it might be trial and error, and maybe it'll get too professional, so I'm not going to do it. And so I think at the end of the day, the benefit of going that route is that there will always be the inequality among schools for the reasons that Michael mentioned. It's just that players could actually get some of it. And so the competitive imbalance now takes the form of everyone other than players getting tons of money. And so if you look at big time college coaches, they're making $5-10 million a year. If you look at the fancy facilities, there are tens, even hundreds of millions of dollars a year. There is a lot of money to go around. At the same time, the student athletes that are making all of this possible are really suffering. There was evidence in the O'Bannon case that the star athletes were pooling their money to go to Taco Bell at dinner. These student athletes oftentimes are on the practice field at the time that the dining halls are open. And so they can't afford dinner. And then if they do some other way, the NCAA will slap them for a rules violation. And so the difference is that while we'll still have the competitive imbalance, at least the players would have a small piece of it rather than the coaches, the stadia, and the NCAA.
I think it's a very complex question, and there are a lot of dynamics, as you're all highlighting, going on. And that's why I think, and I do think the but-for world would be obviously a bit of chaos at first, and then would then settle into some form of equilibrium. And I think a lot of that would get rid of a lot of sports and a lot of sports educational opportunities for an enormous number of people. But all it highlights, everything you're saying, I think highlights, going back to why is the court taking the case? It's because district court judges should not be czars of the NCAA and trying to figure out, oh, this is too far. This will be more like professional, so I can't do that. Or let me tweak it here. Let me tweak it there. It all goes back to the fundamental question, which I will say again, which is, are you allowed to have this as a product, a collaborative product? And if the answer is no, we think it's inherently bad, inherently anti-competitive. That should be a legislative, and I think, and there is legislation going on, which highlights the fact that that's probably where this is best addressed, including many of the points that Hal has raised.
And I think on that tweaking point, the problem, and the petitioners in their briefs talk a lot about micromanagement, and this is not the role for courts to play. The reason why courts are doing this is, first, they are perhaps afraid of the free-for-all that would happen if all these rules were struck down. And so that's why we get a lot of those nitpicky determinations under injunction and the less restrictive alternative analysis. But at the end of the day, the courts are filling in for the failures of the NCAA. So the NCAA has to show a pro-competitive justification. It has to show that its restriction, and it is clearly a restriction, has, quote, severe anti-competitive effects, that this restriction will enhance consumer demand. And it doesn't do it. And so let me just give you one example. If you look at the district court's opinion, page 1100 to 1101, the NCAA has a Rule 30B6 witness, Kevin Lennon. He said, quote, he doesn't recall any instance in his more than 30 years with the NCAA in which a study on consumer demand was considered by the NCAA membership when making rules about compensation. 30 years, they're talking about amateurism, and they're not even connecting it with consumer demand. If this was a normal defense, what you do is you pass a rule. It's pretty restrictive on the student athlete, and then you connect it with consumer demand. You have a study that doesn't say amateurs and or not paid. You have a real study. You show the effect on the consumers. That's what antitrust law is about. And because the NCAA never goes into court with these studies, with these antitrust justifications, the courts have to bend over backwards and say, oh, well, this is how it could affect consumer demand. And it looks like they're micromanaging because the NCAA didn't do it in the first place. And so that is what happened. Just taking a step back, in the Alston and the O'Bannon cases, for the first time, we get to look under the hood of the car. And we see that it's pretty bad. Amateur doesn't mean anything. And the lack of consumer demand means the courts have to do things that they otherwise would not be doing.
Yeah, no, you're just going to the fundamental nature of the product, and then calling it a restraint and calling it facially anti-competitive and saying you need to show that every bit of your product generates consumer demand. That's a bizarre rule of reason. I've never seen it before in my 30 years, and this is one reason I think they took the case.
James, it's not like every restraint that they impose, or everything they call an eligibility rule, imposes a restraint. You've got a singular restraint, no pay. And not even the NCAA took the position that was not a restraint. They said, oh, we have a justification for that restraint. Now,
right. I have a different view, even of that.
Well, we can deal with that after I finish, an opening that you made, and that was, if this were considered by the court outside the what can I say, penumbra, of being associated with a university, just as a regular, product, in a regular joint enterprise, all the court would need to say, you have a restraint, there is no pro-competitive justification, end of story, restraint's got to stop. Maybe.
Oh, yeah, no, if these were
wait,
independent,
wait.
distinct independent competitors, of course.
Maybe the courts should not be engaged in this micromanagement. And they should have just left it to the market to determine within the NCAA or the conferences coming back and saying, okay, well, what about this? But
they certainly could declare, and it would be interesting for the court to say, no, you have it all wrong. Actually, it's not a collaboration. It's really just independent competitors, and they're just price fixing wages, and you didn't even need to do all this. But that, I suspect, will not happen.
Well, already you've been answering, I think, some of the questions that are coming from the audience. So I'm going to sort of switch gears entirely. A very interesting question has come out, and it's asking the panel to predict the future, which we know that, as Yogi Berra says, that's particularly hard to do about the future. So we're going to make a prediction about what if we go into a world where indeed we are paying athletes, and what would be the role of the NCAA as far as regulating things like agents or financial planners? Would those sort of tasks be moved down to the universities? Would there be another type of NCAA entity that moves in, or some arguably some kind of union? What would happen if we had pay, and would there be some form of regulation so that student athletes couldn't be otherwise exploited for the money?
But you could argue that this is no different, again, than a multi-employer, bargaining unit, which would necessitate, a multi-employee bargaining unit, to balance. Or you could, as Michael has said, and some of the economists as well, in both O'Bannon and Alston have said, this could be determined at the conference level as opposed to, the association level. And the NCAA commissioned former Secretary of State, Rice, to look into, its governance of college sports, and it found it woefully failing in that responsibility. So I think there would be a dramatically different role for the NCAA as this umbrella, all controlling, Wizard of Oz type association. You could work this through the various conferences with different rules that would be responsive more to market conditions, or there could be some association of athletes who would at least have a seat at the table in terms of when, these economic opportunities, for example, when one of the video manufacturers comes back and says, well, you know what, we would like to offer, a video game, of college sports again. Should the athletes have a say if their names and images and likenesses are going to be used and are going to be provided in the economic package to the schools, the conferences, and the association?
So I think that's a possibility, but given that so far the NLRB hasn't treated student athletes as labor, you would have a situation where they're essentially now being treated as labor for antitrust purposes, but not for labor law. And then I think it would be what Hal and Matt were talking about. All hell would break loose, and the marketplace, if it's a completely free market, would operate and find some equilibrium. And I suspect that equilibrium would include a lot of money going to a small number of student athletes at a small number of schools and programs, and you would have essentially this highly differentiated product with, I think, losing an enormous number of sports and student athletes being able to play those sports because the money would all be drawn towards the ones that are best for TV. So it would eventually reach an equilibrium, and it would be certainly a different product. That's all I would say.
I think Board of Regents gives an interesting view, because after Board of Regents, you went from the NCAA managing TV to basically the conferences doing it. And I think you'd have the same thing here. There'd be the conferences would organize themselves to schools of similar value or similar appeal with similar attractiveness to players. There would still be this need for some coordination. And so the conferences would likely be where it happened. And you'd probably have, the big five conferences would probably maybe govern themselves a bit differently than some of the smaller conferences. But that seems like the more logical unit. And I think it parallels what's happened in the past.
And Matt gives almost the best response, to the product would look different argument that you make. Yes, after Board of Regents, the product did look different because total control was wrested from the NCAA and given to the conferences.
No doubt.
And
no doubt for broadcast, yes.
But there's no essential antitrust difference in terms of the NCAA imposing an absolute prohibition upon their Division I men's basketball, and football athletes who produce, the revenue, which basically, is the largest alumni contributions, annually in any institution, from having a share, of some of that money that their performances, and their participation and their contracts basically should entitle them to.
How do you think it would play out with kind of a completely free market, setting aside the labor exemption, labor negotiation?
Well, I think that all the parties, including the athletes, would have incentives to want to put up guardrails to protect against all of the spoils flowing to just a handful of athletes. So envisioning exactly, I can tell you, and I'm sure you're aware how that works out in other leagues, right? There are minimum pays for rookies, their maximum salaries. I would suspect that either done through a union of athletes, these sorts of guardrails to protect against massive imbalances in payments could be worked out, or done in coordination with a union representing the athletes in conjunction with the NCAA. But I think that everyone would have strong incentives to make sure that the inequities didn't grow too much. So I respectfully reject the notion that all of the spoils would go to a handful of the top recruits.
All right, as we are starting to close in on the end of our time, gentlemen, what a wonderful conversation. Let's do one more hypothetical, and let's just assume that the Supreme Court rules for the NCAA, who are the petitioners in the current case before the Supreme Court, and that they conclude that under a rule of reason, that analysis in an input market, so to the extent that the Supreme Court is going to hold that the input market is the labor market of student athletes, that we can look to consumer benefits, or the output market is consumer demand, as Michael Carrier has talked about. They haven't made that connection, but let's just assume the court makes that connection for them. What would you advise for next steps?
Well, the next step almost, Babette, maybe regardless of who wins and who loses. If the NCAA loses, I'm sure they'll go to Congress to try to overturn the decision and say that Congress controls what they consider to be a matter of national or public importance. Likewise, if the athletes lose, I think they'll try to do the same, to go to Congress and say, this is unfair. In terms of what otherwise is recognized as a labor market and an exploitation. So I think the next step, regardless of which way the court rules, may be for one or both of the parties to go to Congress.
Yeah, I agree. I think that Congress is likely the next step. All of these discussions that we're having are appropriate in Congress as well. And what I really hope from the court is for an opinion that is consistent with what it has done in the past in terms of antitrust jurisprudence. I hope that there is not an immunity granted on the NCAA in the past. The Supreme Court has been pretty consistent that immunities, that limitations are really cabined very narrowly, that antitrust has a broad scope. And even for things like professional sports leagues and standards organizations, you don't get per se legality, you're still subject to the rule of reason. And I hope that the court says that the rule of reason is the appropriate construct. At the end of the day, I would like to see balancing brought back into the analysis. There is so much discussion on less restrictive alternatives and micromanagement and what the plaintiff has to show. This is just a third step in the analysis, and balancing is hard, but at the end of the day in antitrust law, there has to be some way to consider anti-competitive, pro-competitive effects. And so that's why I hope the decision is consistent with a four-step analysis that focuses on competition, not just what's good for the NCAA, because we know amateurism is what's good for the NCAA, but rather on the market as a whole, consumer demand, and the things that the Supreme Court has recognized for the past century.
So just picking up on what Michael Carrier just said on this issue of balancing, and I'm going to play out this hypothetical that the Supremes go in the direction of the NCAA. I think that we would then have two cases when combined with American Express that fundamentally gets the balancing wrong. That is, the court is telling us that we should tolerate a known harm to a counterparty or a trading party. In American Express, of course, it was merchants because of some purported offset on the other side of the market. That is, if the defendant is able to splash or sprinkle a portion of the overcharges on one party or the underpayment to one party in the direction of another third party, then the conduct is somehow escapes antitrust scrutiny. I'll note that the House Majority Report that just came out in October recommended reversing and nullifying, I think is their words, a slew of Supreme Court decisions that they perceive to be hostile to plaintiffs, hostile to workers. I'm thinking about where the court has upheld or required, upheld the legitimacy of these mandatory arbitration clauses in worker contracts, employer contracts. But I think that what I would advocate for would be a nullification of Amex, and of course now of NCAA if it goes the wrong way, and a clear statement of the types of efficiencies that could be considered in monopsony cases. And I would suggest that the only efficiencies that would work under what I call my no offset rule would be those that redound to the benefit of the trading partner, or in the monopsony case of the worker. So Michael keeps talking about balancing. I just want to make sure that maybe Michael and I disagree on this thing, which is healthy, but I think in a monopsony case, I'd be willing to hear efficiencies that redound to the benefit of workers, right? Like the kind that Matt was spelling out about, he thought that the training facilities would somehow be jeopardized, and that's good for, high training facilities, good coaches are good for athletes. That's fine. That's an efficiency that redounds to the benefit of the worker. But I would suggest under a clear no offset rule that efficiencies that are realized or captured by third parties should be ignored.
Hal, with regard to American Express, and either O'Bannon or Alston, there was a distinction in American Express. The court did not balance. They just said the plaintiffs never got past stage one because they didn't establish the existence of the restraint. I do believe they tried to balance, in O'Bannon and in Alston, but I think it was a false balance because it's a false pro-competitive justification.
I disagree. I disagree with all that, but I would say I don't think but I don't think the court is going to. I would be very surprised if the court recognizes the kind of anti-competitive effects as Michael Howell and Michael describe, if they adopt that view of that as a kind of a standard labor market with these anti-competitive effects, and we're going to see if it's offset by pro-competitive effects, for an amateurism product competing in in the entertainment world. I don't think if they recognize the first that they would say, oh, send it back and do that kind of balancing. Now, certainly there is some balancing even in American Needle with respect to the justifications it highlights in terms of things like competitive balance. But I think this is a different situation. I think they will go more fundamentally to whether this is a legitimate collaboration with a legitimate product, and then work from there.
But then in determining the legitimacy of the product, you'd have to determine again, the essential nature of the alleged pro-competitive defense. So
And with that,
I disagree. Yeah.
And
No.
with that, I have to say we are essentially out of time. This has been a wonderful discussion. I want to thank you all again for such an engaging conversation. Of course, these conversations are meant to continue, and wonderful to have you all here. And thank you so much for your time. This officially concludes our conversation this session. The host would like to invite you back tomorrow at 11 a.m. Eastern. The last session of the symposium will be held then. It's the final arguments of the Global Antitrust Institute Moot Court Invitational. I'd also, on behalf of the sponsors of this symposium, like to thank Freshfields and Charles River Association for their support of the symposium. Again, thank you so much to the panelists on this, and please come again tomorrow for other panel participation. So thank you all, gentlemen, and have a great afternoon.
thank you, Babette.
Thank you, Babette.
Hound, Matt. And
Thank
Mike,
you, everybody.
Thanks, Ed.
Take care.
Bye.
Stay well. Bye-bye.
You too.
Bye-bye.